Hello, everyone, and welcome back to Criminal Law 1, Constitutional Criminal Procedure. Today, we will be finishing up the lecture on interrogations and associated rights. So that being said, let's jump right in. We've discussed Miranda and what your Miranda rights are. And generally saying, in order to invoke your Miranda rights, you have to be explicit in terms of wanting to invoke your rights. That being said, when you waive your Miranda rights, we prefer an express waiver, right? So we prefer that you say, I will like to talk to you, or I don't want an attorney, or something along those lines. But in some situations, implied waivers will satisfy the Fifth Amendment. And to that end, I encourage you to take a look at North Carolina versus Butler. This deals with an implied waiver of Miranda, which is not all that uncommon. All right, so again, we have a preference for express waivers, but sometimes implied waivers will do. So a case came up, Oregon versus Elstad, when we were dealing with Miranda and some of the fallout from it. And it dealt with the issue of, quote, question first, read later. Right, so basically what would happen is police officers would question the suspect, and then after they question the suspect, read him or her their Miranda rights. Now, the Supreme Court intervened, right? And it said that police are required to read or to serve as reasonable notice that the first statement is inadmissible and that the suspect has a choice to continue talking to police. So what this means is if the police decide to question you without reading Miranda, and then they decide to read you Miranda later, anything you say in that first statement is inadmissible. Anything you say in that second statement is inadmissible, unless the police are explicit with you and say, everything you told us in your first statement cannot be used against you at trial. It's inadmissible. Now, would you like to give us another statement after we've read you your Miranda rights, knowing that the first one cannot be used against you? Right, so this kind of circumvented this notion of, well, we'll question them, then we'll read them Miranda, then question them again, right? Get a confession, read Miranda, get another confession. This basically said, no, you have to be explicit that the first confession is inadmissible, and they have the Miranda rights, they have an absolute right to remain silent, absolute right to counsel, etc., before you try to get a second statement out of them. That being said, once you've read Miranda, and as long as the party knowingly and intelligently volunteers a waiver of Miranda, even if they've already given a previous statement, then that information can come into play. So when we're talking about waivers, we have to discuss the following the invocation of Miranda rights. They can occur at any time, right? So when we talk about questions regarding, or an invocation of Miranda rights regarding questioning, this must be, quote, scrupulously honored. So if during questioning you say, even if it's middle of questions, you just decide to stop answering questions, you just said, I want to invoke my right to remain silent, you never give it up, you can always invoke it, then questioning has to immediately cease. The police cannot put pressure on you. They can't say, oh, guilty people say that, some of that. They can't do that. They have to immediately cease questioning. Now, they have to suspend their questioning for a significant period of time. Usually, this is a 24-hour rule. So they can question you, you invoke Miranda, 24 hours later, they can come back and question you. That being said, before they question you the second time, they have to read you a fresh set of Miranda warnings, right? So they have to read you Miranda again. And again, give you the opportunity to invoke Miranda if you so choose, or waive Miranda if you so choose. Now, in terms of how long and what kind of questioning that police can engage in, turns on a variety of factors, right? Specifically the time, the place, and the nature. And we'll get into what does a custodial interrogation look like as opposed to a non-custodial interrogation. So that's if you decide to remain silent. Remember, it has to be unambiguous. In terms of invocation regarding an attorney, this is much more strict, right? So when it comes to an attorney, we have what's called the initiation test. So as soon as you say, I want a lawyer, remember, it has to be unambiguous. The questioning has to stop completely. And unlike remaining silent, the police cannot approach you again and after 24 hours or however long, read you Miranda and ask you more questions. It has to stop until you get your lawyer. Now, there is the initiation test. So we have a kind of a loophole here. The initiation test basically says that if you've asked for a lawyer and they've immediately stopped questioning you, all that jazz, but after a while you say to yourself, well, I should answer their questions, or why you would, I wouldn't know, but you decide that you want to talk to them. You can approach law enforcement and say, I want to answer your questions. Right. Now, that being said, it's usually better to be safe than sorry. So a lot of police departments, even though you initiate the fact that you want questioning, they will read you Miranda again. And if you have an attorney, they'll make sure the attorney is notified well in advance of the questioning. Right. So that way they ensure any confession that comes in is admissible. But again, they cannot, after 24 hours, re-question you. You, as the defendant, the suspect, has to be the one who initiates conversation with the police officers and a decision to answer their questions. So, how do we determine custody, right? And this is a very important point because officers are only required to read Miranda during what's called custodial interrogations, right? So interrogations in which you're in custody. Now, this makes sense to a certain degree, right? Because if you're not in custody, you can just get up and leave, right? You don't have to answer any questions. If you are in custody, you don't have the privilege of getting up and leave, right? You're kind of stuck there. So what we do is we apply an objective test, right? So and here's this term again, under a totality of the circumstances, right? Everything known at the time, would a reasonable person have felt free to leave, right? So based upon everything that was happening, would you feel free to leave if you're a reasonable person? Now, there is no single determinative factor, but factors that we do consider are the number of police officers. So if it's just a one-on-one situation, we're probably going to say you would probably feel a little bit more free to leave than if you had 7 officers and you're the only person, right? It changes the dynamics, it changes the feelings. Next, we ask whether officers tell you or tell an individual that he or she is free to leave, right? So generally speaking, police aren't going to be as upfront with this. They're not going to say, well, you're free to leave. You don't have to answer my questions. You have to ask for the most part, right? So that's why if you ever get stopped by a police officer, always ask whether you are free to leave. If you are free to leave, then leave, right? Don't answer questions, even if you've done nothing wrong. If you're not free to leave, then you are in custody and Miranda applies. And they have to read you Miranda before they can ask you any questions that can be admissible in court. We also look at, when we're talking about the totality of the circumstances, the length and intensity of interrogations, right? So if you've just been asked questions for like 15 minutes, and that's really it, And it's just kind of been some basic questions, when's your birthday? Just some basic kind of innocuous questions. We're probably going to say that doesn't look like custodial interrogation. If, however, we've reached hour 16 and they are asking you questions that are trying to evoke a confession or some other incriminating statement, then we're going to say that looks more custodial. We're also going to look and see whether the stop occurs in public or in private, right? So whether the questioning occurs in public or in private. In other words, if a police officer stops you as you're walking down a sidewalk in a very public area and starts asking you questions, you're probably going to feel a little bit more free to leave than if they corner you into a private residence or even the police station, and we'll talk about whether that's a use of force or not. But basically, if you're in the police station, it's going to be, for the most part, custodial unless you've decided to come down and engage. Now, another thing that we're going to look at, and this is a very big one, is whether the individual is restrained, so generally speaking, handcuffed, or officers otherwise use force. Remember, we talked about there's a continuum of force. So it can be anything from the officer saying, stop, to the officer drawing their firearm, right? So it's a continuum. Any use of force, so officer saying, stop, is probably going to tell us that you're not free to leave, right? Because it's not, can you talk to me for a second, right? You can just say no and walk off. But if somebody says stop, a police officer says stop, you have to stop, right? So if there's this show of force, even just the tone of voice can be a show of force. Under the totality of the circumstances, this is a really big factor that we do consider. We also consider whether the individual was restrained, right? So was the individual in handcuffs? Was the individual non-handcuffs, but were they placed in the back of a police car, et cetera, et cetera, et cetera? Right, so again, the more it looks like we're being punitive, the more it looks like we are considering you as a suspect, the more it looks like we're about to arrest you, the more likely it is, under the totality of the circumstances, you probably would not feel free to leave. We also ask one question, which is interesting, which is your familiarity with the surroundings, right? So if you are in your neighborhood and you're just going for a walk and a police officer asks, hey, can I ask you a couple questions? Okay, you're probably familiar with that area. You probably feel safe. You might know the police officer or know of the police officer, right? That's just kind of the end of it. However, if you are in a strange location, right? So if you are somewhere that you've never been before and you get asked to stop, we're going to say, well, how familiar were you with the location? You weren't really that familiar. So you didn't know if you could walk, if you could run, where you could go to, etc. And in that case, it's not as strong under the totality of circumstances, but it is one of the factors we consider. And again, we also consider, where are you? Are you at the police station? Are you in your home? Are you in public? Where are you? And you'd be surprised, because when you think of like, are you in your home? Most of us would initially go to, oh, that means that you were, felt free to leave. The opposite tends to be true, right? If you're in your home, are you just going to walk out the door and leave the police officers there? Like, probably not, right? And the same thing is true in a police station. That being said, a lot of factors come in to police station interrogations. Everything's from recording to Mirandizing to you name it. Determines whether or not, again, is a factor to be included in our determination of whether or not you're in custody. Now, we do have a special test for children, right? And this comes out of JDB versus North Carolina, which involved a 13-year-old. So what we do is we still look at the totality of the circumstances. We still look at the factors. But we ask ourselves, if that child is a minor, would a reasonable child of that age believe they were in custody? Right? Now, that's really a difficult thing to say because most 13-year-olds don't understand the concept of custody and things like that. So that's why we say, okay, would an objectively reasonable 13-year-old, if it's a 13-year-old, or 10-year-old, if it's a 10-year-old, feel like they were free to leave? Generally speaking, the younger you get, less likely it is you're going to feel free to leave, unless police have told you you can. You're generally going to want a parent present, and before we do interrogations of minors, generally speaking, we do have what's called the interested adult present. All right, so it doesn't have to be a parent, but somebody who's interested in your welfare. But we look at and say, you know, how many officers or how many disciplinarians were there compared to you? Were you told that you were free to go if you wanted to? How long and intense is the interrogation? Right? And again, we're looking at a reasonable child of that age. So for a 10-year-old, length and intensity is a lot different than if you're 17, right? We look at whether their stop is in public or private, right? Whether the child is restrained or there's some other use of force, as well as their familiarity with the surroundings. So take a look at JDB versus North Carolina. It's a really interesting case, but it derives the reasonable child of that age test. It's really the only time that we substitute or we look at things from a different perspective in terms of deciding whether somebody's in custody. Now, there has been issues and questions as to what about if it's somebody with dementia or Alzheimer's, right? So this past year, the Supreme Court handed down a ruling. It was a death penalty case. And the person who was going to be executed for a murder had so severe dementia that they didn't understand why they were in jail. They didn't understand what they did. They don't remember what they did or anything along those lines. And the Supreme Court said, in that instance, well, if this is the case, right, that you don't understand, that you don't remember, that you don't recall, it would be cruel and unusual punishment to put you to death. Now, there have been some stirrings as to what if someone is an adult, but that adult has dementia, right, or Alzheimer's, or they have something along the lines of, again, I hate to use the term, as it's the legal term, mental retardation, mental disease or defect. So let's say they have Down syndrome. Then how do we approach this, right? And this is a really difficult question that no one's really been able to answer, and it hasn't been answered yet. Because if you're talking with somebody who has dementia, a lot of these factors, if you're told free to leave, length interrogation of testing or interrogations, etc., that's going to look a lot more like we would look at a child. Not saying that they're children at all, but we'd still kind of have that same feel to it as if we were dealing with a child. Now, like I said, this really hasn't been addressed by the U.S. Supreme Court, but at some point, I presume it will be. And we will probably see a test from a reasonable child of that age test saying, what is their IQ? What is their ability to reason? And then from there, say, would the person with that ability to reason or with that IQ feel free to leave? That being said, there is one situation where you are in custody, but police do not have to read you your Miranda rights. That is during a traffic stop. So if you get stopped for speeding, you are in custody, right? It's not like you're free to leave. You can't just pull off from the side of the road, take off down the road without initiating a pursuit and all that jazz. You're not free to leave. Now, that being said, your Miranda rights still apply. Now, the police, from what the Supreme Court has told us, is the police do not have to read you your Miranda rights, right? And the rationale is it's such a short encounter or such a short time spent with a police officer, usually you're in your own vehicle and things along those lines, that it'd be unreasonable to read you Miranda, even though it takes 5 seconds to read Miranda. So that's why I always say, if you get stopped by police, never answer the question, do you know why I stopped you? Because your Miranda rights apply. You have the right to remain silent. You have the right to a lawyer. If the officer comes up into your window and says, well, hi, I'm Officer so-and-so, do you know why I pulled you over today? Say, I invoke the right to counsel, because that lawyer or that police officer cannot do anything but just give you the ticket and leave. Again, most of the time it's not a problem, but keep in mind there are times that police can be corrupt. And so this is really for your own safety and really your own benefit. But remember that Miranda does absolutely apply if you are stopped for a traffic infraction, right? You're under custody. You're not free to leave. So remember, your Miranda rights do apply. I recommend always invoking them. Again, recall that to pull somebody over, all you need is reasonable suspicion that they were speeding or that they were breaking some kind of law. So the officer might not have enough proof to say that you were speeding. But if you tell the officer, oh yeah, you pulled me over because I was speeding, I was going 77 and a 50, well, then you've just confessed, right? No real different than a confession to any other crime. So again, Miranda does apply during traffic stops, but generally police do not have to read them during traffic stops. So how do we determine whether something is interrogation, right? Because Miranda applies to custodial interrogations. Now, we have just discussed custody pretty in depth. Let's talk about interrogations, right? The second half. So an interrogation is defined by express questioning or its functional equivalent. Now, express questioning is fairly easy to identify because you say, like, they're asking you questions and they're very explicit. That being said, when we think about functional equivalent, it's the most difficult to identify because it consists of, and this is a quote, words or actions on the part of police other than those normally attendant to an arrest and custody that the police should know are reasonably likely to elicit an incriminating statement or response. So there are a couple of cases that I really highly recommend that you read because they are fascinating cases. We have Rhode Island v. Ennis, which is a missing gun case. Basically, guy goes in the grocery store, hides a gun somewhere, and the police are talking like, hey, it'd be really bad if somebody found that gun, kid got a hold of that gun, something could happen to him. And then Ennis felt bad and basically told him where the gun was, right? And so the question is, in that case, was that an interrogation? That one was, it's a little bit more of a difficult case. Generally speaking, in that case, it was not interrogation. But there is a great case on point that deals with this issue. And it's very famously known, not as Brewer v. Williams, but it's famously known as the, quote, Christian burial speech, right? So what basically happens, and this is sometime before the arrest, a 10-year-old girl was with her family at the YMCA, right, to watch her brother participate in a wrestling tournament. She went to the bathroom and she never came back. Search began, and the search was unsuccessful. A man named Robert Williams had recently escaped from a mental hospital, and he was a resident of the YMCA. Soon after the girl's disappearance, Williams was seen in the YMCA lobby carrying some clothing and a large bundle wrapped in a blanket. He actually obtained help from a 14-year-old boy in opening the street door of the YMCA to the door of his automobile parked outside. When Williams placed the bundle in the front seat of the car, the boy saw 2 legs in it, and they were skinny and white. Before anyone could do anything to see what was in the bundle, Williams drove away. He abandoned his car, and then he was found the following day in Davenport, Iowa, but roughly 160 miles away. A warrant at that time was issued in Des Moines for his arrest on child abduction charges. Now, some time goes by, and on the morning of December 26, a Des Moines lawyer goes to the Des Moines police station and informed officers present that he had just received a long-distance phone call from Williams that he advised Williams to turn himself in to the Davenport police. Williams surrendered the morning to the Davenport police, who booked him on the charge specified in the arrest warrant and gave him the required Miranda warnings. The Davenport police then telephoned their counterparts in Des Moines to inform them that Williams had surrendered. The lawyer was still in Des Moines at the police headquarters, and Williams conversed with the lawyer via the telephone. Now, that being said, in the presence of the Des Moines chief of police and the police detective, the lawyer advised Williams at the Des Moines police station he'd be driving to Des Moines to pick him up, and the officers would not interrogate him or mistreat him. And Williams was not to talk to the officers about the missing girl until after they could meet. As a result of these conversations, it was agreed by the lawyer and the Des Moines, Iowa Police Department that one of the detectives and a fellow officer would drive to Davenport to pick up Williams, and that they'd bring him back to Des Moines, and that they would not question him during the trip. Now, they complied with this fully. They did not question him during the trip, theoretically. So in the meantime, Williams was arraigned before a judge in Davenport for an outstanding arrest warrant. He was advised of his Miranda rights and committed to jail. Before leaving the courtroom, Williams conferred with a lawyer named Kelly, who advised him not to make any statements until consulting with his lawyer in Des Moines. So when the officers arrive, right, to pick him up, they understood that Williams had a lawyer. Detectives repeated the Miranda warnings and basically said, we both know you're being represented here by Mr. Kelly, and you're being represented by Mr. McKnight in Des Moines, and I want you to remember this because we'll be visiting here in Des Moines. So what basically happens is police officers, they get in the car, right? Remember, there's supposed to be no interrogation during the drive back. What ends up happening is the conversation between the two officers in the front of the police car suddenly takes an interesting turn, right? So the detective and the prisoners embark and they engage in a wide range of conversation from a variety of topics, including the subject of religion. Then, not long after leaving Davenport and reaching the interstate highway, the detective delivered what was referred to as, in briefs and oral arguments, as the quote, Christian burial speech. Advising Williams as Reverend, the detective said, I want to give you something to think about while we're traveling down the road. Number one, I want you to observe the weather conditions. It's raining, it's sleeting, it's freezing, driving is very treacherous, visibility is poor, it's going to be dark early this evening. They are predicting several inches of snow for tonight. And I feel that you yourself are the only person who knows where the little girl's body is. That you yourself have only been there once. And if you get snow on top of it, yourself may be unable to find it. And since we're going right past the area on the way to Des Moines, I feel like we could stop and locate the body. That the parents of this little girl should be entitled to a Christian burial. For the little girl who was snatched away, feel we should stop and locate it on the way rather than waiting until morning to try and come back out after a snowstorm. Now, they said this theoretically to one another, and they said this in full earshot very loudly for Williams to hear, right? They did not ask him any questions, right? It was just a speech about how, because they had talked about religion, how this person deserved a Christian burial, et cetera, et cetera, et cetera. Williams asked the detective why he thought the route to Des Moines would take them past the girl's body. The detective responded that he knew the area this occurred in, and they'd be passing on the way to Des Moines. The detective then stated, I do not want you to answer me. I do not want to discuss it any further. Just think about it as we're on the road, right? So of course, what happens is his conscience gets the best of him. And the question becomes, and Williams, was there a violation of his Miranda rights? Right? Because they agreed not to question him, and they didn't question him. They just gave a speech. And they even told him, don't answer us. So what happens here? So in this case, we're dealing with what constitutes a waiver, right? Here was an interesting case because the defendant had been indicted in court and asserted his desire to have counsel. Thus, his Sixth Amendment right to counsel had attached. At issue is whether there was a voluntary admission of incriminating facts in response to police statements while the defendant was in custody and outside the presence of his lawyer, and whether they constituted a waiver of his right to counsel. So the Supreme Court ultimately comes down and says Miranda safeguards come into play whenever a person in custody is subject either to express questioning or its, quote, functional equivalent, right? And they basically said in this case, this was a functional equivalent, right? So the note that I have for you is once Sixth Amendment right to counsel attaches at initial appearance before a judicial officer or when requested by a suspect, remember he was arraigned on the outstanding warrant, he requested the lawyer, police can no longer deliberately elicit an incriminating statement absent a waiver, right? So otherwise, no interrogations. And so in this case, we had to ask ourselves, were the actions of the police designed to deliberately elicit an incriminating statement, even though they never asked any questions. Well, remember, in the car ride, they learned he was very religious, referred to them as reverend, talked about the Christian burial, right? It was very obvious what they were trying to do, right? And it worked. But the Supreme Court said, sorry, you tried to deliberately elicit an incriminating statement after somebody had asked for counsel. You can't do that. Now, absent a waiver, right, in this case, you approaching them, it's not permissible. So again, in other words, no interrogations. So let's just quickly review when we talk about the triggering of Miranda, right? So officers are only required to read Miranda during custodial interrogations. And we have just spent the past few minutes discussing what it means to be in custody and what it means to be interrogated. Now, if both one, custody, and two, an interrogation is present, then officers are required to read Miranda. If they use statements against the particular only if they use the statements against the particular suspect, and only for testimonial evidence. So recall, communicating a message is very different than being a handwriting exemplar or a voice exemplar. So when we look at the test for custody, we say under totality of the circumstances, would a reasonable person have felt free to leave? Remember, there's special rules for minors. And then when we ask about interrogation, it's defined by express questioning or its functional equivalent. So the test for interrogation is words or actions that the police should know are reasonably likely to elicit an incriminating response. So take a look at the missing gun conversation versus the Christian burial speech. You'll see there's a vast difference between the two, though many argue that they are functionally the same. So let's quickly address an exception to Miranda. So there is an exception to the Miranda rights. Now, they apply, but the police don't have to read them to you. This is called the public safety exception. And it permits police to ask questions before reading Miranda if reasonably prompted by a concern for public safety, right? So we'll talk about an example here in a minute, but if you're concerned about public safety, you don't have to read somebody their Miranda rights, and anything they say can be used against them, even though you did not read Miranda. But generally speaking, public safety has to be the option, has to underlie this. Now, that doesn't mean Miranda doesn't apply. It absolutely does, right? If you're in custody and you're being interrogated, Miranda applies. You can ask for a lawyer and they have to stop. They just don't have to read it to you. Now, when we look at when this exception is triggered, three factors have to be present. One, police must have a reasonable belief that a threat is immediate. Two, questioning must be directed towards protecting public safety rather than establishing guilt or innocence. And three, the statements must not be the product of police compulsion that overcomes the suspect's will to resist. Now, there's a very famous case on point, New York v. Quarles, which discusses kind of how vague this public safety exception is, as well as United States versus Reyes. Now, to put it in context, let's talk about the Boston Marathon bomber. Right, there were two brothers. Obviously, they set pressure cooker bombs in the Boston Marathon and killed like 3 or 4 people, maimed like hundreds of more. Anyway, after a long police chase, after a couple of days, like they shut down the whole city of Boston. After the police chase and their Schneider brothers are throwing out pipe bombs and stuff like that at the police. They get cornered. One of the brothers tries to make a run for it. The younger brother accidentally runs him over and kills him, and then flees and gets away from police, and then hides in this town. The next day, the police go from house to house searching for him, right? And ultimately, right before they give up the search, they find that he is in a boat in somebody's backyard. Now, so I've fired a round. In response, approximately 30 police officers shot into the boat. And like emptied their clips, right? So we're talking like hundreds and hundreds of rounds got fired. So Tsarnaev is hit, but somehow, inexplicably, survives. Now, Tsarnaev is taken to the hospital, right? Because even if you're accused of something terrible, you still have the right to medical care. So he's taken to the hospital, and police start asking him questions, right? Specifically tailored to, are there any more bombs out there? Are there any more bodies? Is there anybody that you're working with? Do you have an accomplice? Et cetera, right? And they did not read Tsarnaev his Miranda rights. And the argument, which I don't like how this case came out, I mean, he's guilty, but he deserved a fair trial. But the argument, I believe, right, was this was a public safety issue. Because, again, police must have a reasonable belief that a threat is imminent. Well, just a little while ago, he was throwing pipe bombs at them and shooting. Right? So we need to know if there's any more bombs out there. The questioning was directed towards protecting public safety and not establishing this person's guilt or innocence. Like, they had enough to establish his guilt. Like that was just, there was no question about it. But they were there to protect public safety. That's why they asked him about the bombs, if there were any more. Is there anybody he's working with that's still out there that might have bombs, whatever. And then this is an interesting scenario, because the statements and the questions that police give must not be the product of police coercion that overcomes the suspect's will to resist. Now, Tsarnaev legitimately was riddled with bullets, right? I mean, it's questionable if he was going to survive. Now, in this case, he ultimately did survive, and courts have held that no, it was public safety exception, right? That they didn't overcome his will. That being said, there have been cases where police officers have dressed up like doctors or have dressed up like members of the clergy and told the person in the hospital completely falsely that they were dying. And as such, they should, if they want to get into heaven, they have to have a clear conscience. They have to admit everything. Well, of course, I mean, most people are in that situation, they think they're dying, they're going to start admitting everything. Well, the thing is they thought they were talking to a doctor, or they thought they were talking to a member of the clergy, when in fact they were talking to a police officer, right? And that they weren't dying. These are the situations where we say, okay, it was police compulsion that overcame your will to resist. You wouldn't have made the statements if it wasn't for the police officer's actions. So that kind of just gives you an idea. Again, read Nerfi Quarles, United States versus Reyes, and definitely if you're interested, I'm always more than happy to talk about the Tsarnaev case. I worked on it, and it's a fascinating case. So that being said, in the next class, we're going to look at the exclusionary rule and entrapment. As always, if you have any questions, feel free to email me. Thank you so much for listening.